Okay, good afternoon. This is McQueen versus Baskin. It's a motion to dismiss. Is that correct?
Yes, Your Honor.
Okay, Mr. Is it Vote?
Yes.
Okay, you're for the defendant. Is that correct?
Yes.
Okay.
For Carole Baskin and Carole Baskin and Howard Baskin are also in attendance at the hearing.
Okay, and Miss Hanna, I see, is on. Miss Hanna, you're for the plaintiffs as well as Mr. Phillips, I believe.
Yes, Your Honor.
All right. And is somebody a court reporter? Okay. You're on mute, but I assume that you can hear us. If not, let us know.
Yes, that's me, Judge. I'm the court reporter. My name is Michelle. Nice to meet you.
All right. Nice to meet you too. All right. Is there anybody else that I'm missing that we need?
Good afternoon, Your Honor. Craig Rothbard on behalf of Carole Baskin as well.
Okay. Sorry that I missed you. It just says Craig on there, so I wasn't sure if you were just observing or what was going on today.
Apologize. I have to use my cell phone. My computer decided to do its usual updates in the middle of trying to log in. So it could be another half hour, but I'll be back on my laptop shortly.
All right. Well, I too am having a little bit of trouble with Zoom today. My last hearing, it kept telling me I had an unstable internet connection, which I'm not really sure how the courthouse internet connection is unstable, but that's what it kept telling me. So if during the course of this, it appears that you can't hear me or that it's becoming unstable and is causing a problem, if you all will let me know, I will I don't know how I'll fix it. I'll work on it if I need to. Okay. It seems to have corrected itself. My last hearing, by the end, it was working fine. So I'm going to hope that it continues in that regard. So we've got everybody, right?
Yes, Your Honor.
Okay. So this is the defense motion. So I'll hear from them first. After that, I'll hear from the plaintiffs. I'm not sure if that's going to be you, Mr. Phillips, or you, Ms. Hanna. Whichever one of you is certainly fine. Not sure who's doing the talking today. Okay, so it'll be you, Mr. Phillips. So I'll hear from you second, and then if you have any time left, Mr. Vote, you can have any time remaining there for rebuttal, okay?
Thank you, Your Honor.
Okay, before we start, I generally do not mute myself because I forget to mute myself, but it's been a little bit noisy in the hallway today. So I'm going to put myself on mute so that I don't have any issues with the noise. But if I end up starting to try and talk to you and I have forgotten to unmute myself, please tell me. Because there is a strong likelihood that I will forget. So if I do and I need to unmute myself, please remind me. Okay. All right. I'm going to go on mute and turn it over to you, Mr. Vote.
Thank you, Your Honor. And so I guess the best place to start is the anti-SLAPP statute. So we brought this motion as a motion to dismiss and as a motion for summary judgment under section 768.295. And filing a motion in the alternative like that is explicitly permitted under subsection 4. There's a disagreement at the outset based on the opposition we received that the anti-SLAPP statute applies. So I guess the best place to start is to go through and explain to the court why it applies. The statute is intended to protect rights of free speech in connection with public issues. And it defines free speech in connection with public issues as being any written or oral statement that is protected under applicable law and is made in or in connection with, and there's several types of works listed in the statute, including a television program, an audio-visual work, a magazine article, a news report, or any other similar work. And so the in connection with and or other similar work, there are obviously sort of open-ended catch-alls. Because the statute is a remedial statute, which I'm sure, as the court knows, they have to be construed broadly in order to protect the rights that were granted in the statutes and that the statutes are trying to protect. So with respect to the publications that are at issue here, all of the defamatory statements upon which this lawsuit is based were either on a YouTube vlog, a video blog operated by Carole Baskin, or on the Big Cat Rescue website. And both of those forums, obviously, Your Honor, are internet-based. They're widely publicly available. And as the court in Tobanicki v. Novella stated, websites accessible to the public are considered public forums for anti-SLAPP purposes. So the publications here.
Can you tell me the name of the case again, please?
It's Tobanicki versus Novella. And the site for that is 108 F sub 3rd 1299, and the pinpoint site's at 1308. And so essentially, Your Honor, Ms. McQueen's argument is that the anti-SLAPP statute doesn't apply because it has to be clear on the face of the complaint that the claims are meritless and serve primarily to silence a concerned citizen, which is not the correct standard. They don't actually have a citation in their opposition at page 17 for that because it's just wrong. The second DCA was really the first court to address the anti-SLAPP statute in Gundel versus Avatar. That's at 264 Southern 2nd 304. And what they did was they basically ran down the application of the statute and what it does. And it's significant here because an anti-SLAPP motion is not your typical motion to dismiss. What the second DCA said in Gundel was the way this statute operates is that a plaintiff, when a defendant files a motion under the statute, they just have to make a prima facie showing that the statute applies, which clearly we have here because we've got publicly available forums on which the allegedly defamatory statements were posted, and they clearly concern public issues. And I'll run down the public issues in a second for you. But so once that happens, Your Honor, under Gundel, the burden shifts to the plaintiff. And the plaintiff has to go through and show two things. And if evidence has been filed, they have to refute the evidentiary filing that we've put forth in the record here. But they have to show that the claims are not meritless, and they have to show that basically that the case doesn't involve protected speech. That being that the causes of action that are alleged are not based on protected speech, which clearly can't be done here because these defamatory statements were made on a blog and in articles that were posted on a website. And that's an important component of the statute, Your Honor, where the burden shifts to the plaintiff, because obviously that's not your typical scenario. So with respect to the public importance or public issues component of the application of the statute, speech on matters of public concern is at the heart of the First Amendment. And so what this case deals with, Your Honor, is a number of statements that were related to a number of public issues that were extremely important and widely discussed. Those include, and we point this out in our motion, but there was the disappearance of Don Lewis, Carole Baskin's former husband. That was subject to widespread news coverage locally and nationally. And we filed in support of our motion exhibits 30, 31, and 32 are news articles that go through the Don Lewis disappearance in detail, as well as conservatorship litigation that followed that was also highly followed by the press and the public. And more recently, the Tiger King Netflix series came out just as lockdowns were being implemented in March of 2020. The Tiger King series sort of followed the life of Joe Exotic, who was portrayed as being a rival of Carole Baskin, who operated a sanctuary. And it was viewed by over 64 million people publicly. It became, as what reports have shown, and we filed these, Your Honor, in support of our motion, but a cultural phenomenon. I mean, it was everywhere. I mean, at one point, I think Joe Exotic was petitioning President Trump for a pardon. So it was everywhere. Clearly an issue of public importance and an issue of public concern. And then Ms. McQueen herself, plaintiff in this case, she appeared in Tiger King and gave interviews that actually appeared in episode 3 of the series. The statements that were included in that episode from Ms. McQueen directly relate to the subject matter of the defamatory statements that are at issue in this case. And we filed the transcript with the court of that episode. It's at Exhibit 29. But in addition to that, Ms. McQueen also appeared on other media outlets and discussed Tiger King as well as Carole Baskin, as well as the facts related to the conservatorship litigation and the disappearance of Don Lewis. And we filed those as well, for Your Honor. One of them in particular, it's called Jack Ripper Media. And we've included some images of that in our motion. At page 15, it actually shows Ms. McQueen appearing in that. And there's actually an image put up of one of the defamatory statements that is at issue in this case. And again, Ms. McQueen was also the subject of the news coverage that took place back during the time period of 1997 to 1998 when the conservatorship litigation was going on. So once we've gone through and established our initial burden of the statute, which clearly has happened here because you have speech taking place and it's on an issue that is considered public, then the burden is supposed to shift to the plaintiff to satisfy the two components of the statute, which is, number one, they have to show that their claims are not primarily based on protected speech, which can't be shown here because all the claims here are based on speech. And it's important to note, Your Honor, on that point, that on that first issue under the statute, the inquiry is not whether or not the claims are actionable on some constitutional or statutory or common law ground. The inquiry there is, are the claims based on speech? And here they clearly are. And that's laid out in Gundel. That's at page 314 in the Gundel opinion. And then the second thing that the plaintiff has to show is that the claims are not without merit. And as the court laid out in Gundel, and unlike your typical motion to dismiss scenario, when these types of motions are filed, the plaintiff can't rest on the allegations in the complaint. The court is not supposed to accept those allegations as true. And the court is not supposed to draw all inferences in favor of the plaintiff. The plaintiff has to actually demonstrate that the claims have merit and to rebut anything that the defendant has put forth in support of the anti-SLAPP motion. And our evidence here, Your Honor, is not refuted. And quite frankly, I don't think it could be. I mean, it's a narrowly focused motion. Most of the facts that we rely on are the statements themselves and the publications as a whole, but then also it's statements that Ms. McQueen made, her interviews, things like that can't reasonably be disputed. So in terms of whether or not the plaintiff can meet the burden of showing that her claims are not without merit, we've laid out several reasons why these claims fail in the motion. And I just want to touch on them for the court. The first one is a failure to comply with section 770.01. of Florida statutes. That would bar the entire action, Your Honor, because failure to satisfy Section 770.01 is a failure to satisfy what the courts have determined to be a jurisdictional condition precedent to filing suit. And it's undisputed in this case, Your Honor, that the plaintiff did not serve a 770.01 notice until after she had brought her defamation claims. The first time those claims were brought were in an amended complaint that was deemed filed as of a November 20th of 2020 order. That's a docket 36. We moved to dismiss that amended complaint, including on the basis that there was no 770.01 notice. And then after that, on January 27th of 2021, is when the plaintiff delivered a notice trying to comply with the statute. The statute says that before any civil action can be brought, that's basically for a claim for libel or slander in a newspaper, periodical, or other medium, which is the important keyword for the court there on the issues raised in this motion. The plaintiff has to serve a notice at least 5 days before filing the lawsuit, which wasn't done here. We cited a couple of cases in our motion, Your Honor, Davies versus Bossert, and the Tobinick versus Novella case. They both discuss how notice under the statute has to be given before the lawsuit is filed. This is not something that can be cured after the filing of the lawsuit and then a subsequent amendment of the complaint. And I'll give the court a couple of authorities on that specific issue in a second. But this requirement is so severe, Your Honor, that in one case, the second DCA, Conoco versus Callaway, actually dismissed a complaint that the plaintiff has filed because they didn't comply with the statute and send the required notice laying out what the defamatory statements were and giving the defendant time to correct. The statute of limitations in that case ran while the case was pending, but before it was dismissed, and the second DCA still affirmed the dismissal because that's how seriously courts take the requirement that this statute be complied with.
I'm sorry, tell me that case again.
It's Davies versus Bossert. I'm sorry, that one was Conoco versus Callaway. And it's in, I don't know if Your Honor has the notebook that we delivered, but that's at tab 8 of the notebook.
Okay, can you just put the case site on the record so the court reporter can take it down?
Yes. It is 26 Southern 3rd 53, Florida 2nd DCA 2010.
Okay, thank you.
And so it's an extremely serious, failure here, Your Honor, to comply with that statute. The plaintiff's primary argument in response is that she doesn't believe that Ms. Baskin is protected by the statute because she's not a quote unquote media defendant. And this is an issue that recently has been examined a lot by the courts. So basically what the controlling law says is that when courts are looking at whether or not someone falls under the protection of the statute, the key issue, even though this term media defendant is used, is to look at whether the publication at issue is operated to further the free dissemination of information or disinterested or neutral commentary or editorializing as to matters of public interest. Which again, we've already talked about the public interest component of this in connection with the anti-SLAPP statute, but this is clearly and involves something that is of huge public interest. And really the question is, is the published material, was it published to initiate public debate or to get something out there to spark public interest on an issue? The two primary cases that we rely on, Your Honor, which are fairly recent, are Commons versus Van Voorhees, which is at 135 Southern 3rd 545. And that case is important, Your Honor. It actually has a detailed analysis of all of the different cases that have sort of grappled with this other media inquiry under the statute, including analyzing all the cases that the plaintiff cites in their opposition. And in that case, what the court determined was that a blog, an individual who operated a blog, was entitled to notice under the statute because the blog put out information to the public. In this case, obviously, a number of the defamatory statements here were on a vlog, a video blog. So the logic of that case applies squarely with those components of the claims that are at issue here. The other case that we primarily rely on, Your Honor, is the Plant Food Systems versus IRE case, which is at 165 Southern 3rd 859. And that decision actually relied on the Commons case and said that articles posted on a website were entitled to the protections of Section 770.01. And the quote there was, "The website is a public medium engaging in the free dissemination of information, commentary, or editorializing matters of public interest." And again, the balance of the statements that the plaintiff sues on in this case were in articles that were posted on the Big Cat Rescue website. So those cases, Your Honor, clearly establish that Section 770.01 applies to Ms. Baskin. And I'll point out for the court, just because there's some mention between a media defendant and trying to identify, Ms. Baskin as a private individual. In Mancini versus Personalized AC, which is at 702 Southern 2nd 1376, the court there established, and again, this was another case that was discussed in Commons, but 770.01 applies to the publication itself, the website, the newspaper, the entity that operates it, as well as to the individuals who wrote the stories or articles or language there. So the statute covers individuals as well as entities is the main point to talk to the court about on that. And again, the articles and the vlog at issue here, it can't really be disputed that those are sources of information to the public. And we put all this in our motion, Your Honor, and filed, we filed a copy of the pages for the Big Cat Rescue website. That's Exhibit 45, showing all of the different information that it includes on a variety of topics, advocacy for big cats. It has an entire page devoted to Carole Baskin herself. That's at Exhibit 56 of the materials that we filed. There's a news section. And then the vlog, we also filed the sort of landing page for the vlog. Ms. Baskin's actually been operating the vlog for close to 10 years. The videos go back 10 years. They cover a variety of topics. The operations of Big Cat Rescue, legislation relating to big cats, her personal life, the situation involving Don Lewis and the conservatorship, and then her video diaries, which are the bulk of the statements that are at issue in this case. And so Ms. Baskin herself has actually been recognized publicly, and we filed these materials in support as well, but she's been recognized for the fact that she uses YouTube and social media and things to get out information to the public on issues of public concern. The plaintiff responded to our argument by citing a couple of cases that I just wanted to point out to the court. The main case they cite is Zelinka versus American Health Scan, which is at 763 Southern 2nd 1173. And they cite that for the proposition that 770 applies to media defendants, not private individuals. And it's important to note what the holding actually is in that case, Your Honor, which is, and I'll quote it, "We conclude that the notice requirement, which would be under section 770.01, does not apply to private individuals who post on a message board operated by someone else. So you have clearly a different situation in that case than what you have here. The individual in that case didn't operate the website or the forum, wasn't involved in it. They were just posting messages on a message board. And the court there said, no, that's not going to be someone that's entitled to the protections of the statute. And in fact, Your Honor, the Commons case that I told you about before distinguishes the Zelinka case on that ground. The situation where you have a private individual posting something on a message board as compared to a situation where you have a blogger, or in this case, a vlogger, operating their own site or page or forum on which they're posting information for the public. The other two cases that the plaintiff relies on to try to argue that the section 770 does not apply are the Ortega versus Banco Central Ecuador case and the 5-4 Entertainment versus Rodriguez case. And again, those are both cases, Your Honor, that the Commons case distinguished on this specific ground, which is that both of those cases involve people who put out press releases to the public, just posted them on a website or sent them out through a PR agency. And that, again, just like Zelinka, is a completely different situation than what you have here. When you look at the way that the Big Cat Rescue website and the vlog page actually operate. It's not an isolated incident of someone posting something online. Now, the failure to comply with 770.01 is fatal to the case. The case has to be dismissed. And again, I mentioned the Tobinick case previously to the court, as well as the Conoco case. There's another case that makes that even more clear. It's Orlando Sports versus the Sentinel Star, which is at 316 Southern 2nd, 607. The pinpoint site 610. They noted that under 770.01, a cause of action has to exist before the suit is filed, and that a cause of action that's based on libel or defamation doesn't exist until the statute has been complied with. And so the court stated there, point blank, that the plaintiff cannot cure a defect of non-existence of their claim by amendment, because it would be a subsequently accruing right. So what the plaintiff is trying to convince the court to do here, which is allow her to pursue the second amended complaint based on the untimely January 27th of 2021 notice, it can't be done. The only case they cite in support of their position on that, Your Honor, is the Edward Nezalek versus Sunbeam TV Corp case, which is at 413 Southern 2nd 51. That case, if you actually look at the facts, the plaintiff in that case actually did serve a pre-suit notice. What the plaintiff did there was they failed to allege in the complaint that they had satisfied all conditions precedent, which was a technical deficiency. So the court allowed the plaintiff there to amend to fix the fact that they had failed to allege in their pleading that they had satisfied conditions precedent. But the court did not allow them to serve the notice after the lawsuit was filed and then amend to sort of rewrite history and correct the problem after it had already occurred, which is what the plaintiff is seeking to do here. And as we said, Your Honor, that's an issue on which dismissal of the entire case would be required. If the court were to allow the case to proceed, we've also identified a number of problems substantively with the claims in this case. The The elements of a cause of action aren't really disputed, Your Honor, for defamation. It's a false and defamatory statement of fact that has to be published by the defendant. It's of and concerning Ms. McQueen, that's not privileged, and published with the requisite degree of fault. And on the issue of the requisite degree of fault, Your Honor, we and I'll address this in a second, but we maintain that Ms. McQueen is a public figure and therefore has to establish the actual malice burden under Times v. Sullivan. Just from a basic pleading perspective, Your Honor, when plaintiffs bring defamation cases, the law requires them, and we cite these cases in our motion, and it's not disputed. The plaintiff agrees in our opposition, but you have to allege the substance of the statements that were made, who made them, and when they were made. And additionally, in terms of even a pleading aspect of a case, when public figures are involved, there's a clear and convincing standard of evidence that applies to them for pleading purposes and for proof at summary judgment and at trial. The cite for that, Your Honor, is Palm Beach News versus Early, which is 334 Southern 2nd 50. There are several statements in this case, Your Honor, and why I brought up the importance of alleging when the statements were made in the complaint. There are several statements here that are barred by the statute of limitations. And we've filed and sent over to the court. We tried to put together a chart just to kind of lay out the statements, what publications they were in, and then the exhibits we filed showing the publication as a whole, which the court has to consider on these motions. And I'll talk about some of the law on that in a second. But statement one, which is a statement that was supposedly made in Cattails magazine, that's identified in paragraph 23 of the complaint, that was actually published back in 1997. And we filed some documents in support of our motion. Exhibit C to our motion is actually a petition for an injunction that Ms. McQueen herself filed back in the conservatorship litigation that actually identifies this statement in the Cattails magazine. And it was a basis of her allegations about libel and slander way back then. And in addition to that, Your Honor, the press actually reported on this same court filing. Exhibit 32, we filed a Weekly Planet article that was published back in 1999 that actually, and there's an image of it at our motion at page 45, but it actually identifies this statement about the supposed embezzlement of $600,000 and taking out a life insurance policy. It talks about those exact same statements being made in Cattails magazine in this court filing. So that's clearly barred by the statute of limitations. Statute of limitations is 2 years on defamation claims under 95.114, and Florida statute 770.07 establishes that a cause of action for defamation accrues at the time of publication.
Interrupt you for a moment. You've said that's at what tab number?
Are you talking about the
You said the Weekly Planet argument?
Filed, it would be exhibit 32. We didn't include all of the exhibits in your honors notebook, but if you have a copy of the motion.
Exhibit 32 to the motion, not in the binder you gave me for the.
Right,
okay.
Right. It's in the court file.
Okay, that's fine. I just wanted to clear up whether you were talking about what was filed versus what was in your hearing binder.
Yeah. So the Weekly Planet article is the numbered exhibits were attached to a declaration that we filed in support of the motion. The motion itself has an exhibit C, which we also filed as a numbered exhibit just to be safe. But exhibit C is the petition for injunction that Ms. McQueen filed that references this specific publication. The other statements that are barred by the statute of limitations are on our chart, we've identified them as statements 50 through 52. Those were actually published in 2015. And we actually included a Wayback Machine printout that was from March of 2015, showing that article was actually up at that time period. And so those statements are barred by the statute of limitations as well, because they're well outside of the 2-year limitations period.
We'll withdraw, sorry to interrupt, but we'll withdraw 50 to 52, just to make that a non-issue.
Okay.
You're withdrawing. When you say 50 to 52, what are you referencing?
It's my understanding that there are old claims. We're not pursuing anything that's over 2 years old, and if 50 and to 52.
Are you talking about 50 or 52 in the complaint, paragraphs 50 to 52, or exhibits 50? Like, be clear about what you're.
Sorry, Your Honor. It's the chart. We had a chart hand delivered over. It got to be cumbersome, very difficult to identify by the complaint. So we sent over a chart where we have a number for each statement, the statement itself, and then the paragraph of the complaint, the Second Amendment complaint that it's alleged in. And so, but I can identify those because they've got we have the paragraph numbers, but it's 50 through 52 are paragraphs 34I, paragraphs 34J, 34K, and 34L of the Second Amendment complaint.
All right. Thank you, Mr. Phillips. I will make sure, well, everybody make sure that you please make a note that they are conceding that they're not going to go forward on those things because they acknowledge the time limitation. Go ahead, Mr. Bell.
All right, Your Honor. So that statute of limitations issue is fairly narrow. So then we get to really the initial hurdle in a defamation claim, which is whether or not the statements that they've alleged are capable of having a defamatory meaning. And what they've done is just listed the statements in the amended complaint, not the publications in which they appear. And it's a situation where they say, oh, she embezzled. Oh, she said that she did this. She said that she was a criminal, things like that based on these statements. But the law on determining whether a statement that's alleged to be defamatory can actually have a defamatory meaning has some specific rules that govern it. It's determined as a matter of law at the outset by the court. It's an objective standard that has to be determined based on looking at the publication as a whole. So you can't just pull out that statement and say, look, it's defamatory. You have to look at the entire publication and the context in which that publication and that statement were made. And the court you're not supposed to read them as extremes. You look at how a reasonable person would read them. And there's a couple of.
So when you say that I have to look at the publication as a whole, does that mean to say that I have to look at the whole article as opposed to the whole newspaper?
You have to look at, so in terms of the alleged defamatory statements that appear in the articles on the website, you have to look at the whole article, including its title, images that are in it,
So
all
it's
that.
the whole article, but not necessarily everything that's on the website, or not necessarily every blog that's posted. It just has to be the whole article or the whole piece. Basically, you have to look at the entire context of that particular piece. I can't just look at one sentence.
Yes.
Okay.
However, I do have one caveat to that, Your Honor, which is this. In terms of the video diaries that appear on the vlog, what the law says, and we cite this in our motion, but I'll give the cite to Your Honor. the Smith v. Cuban American National Association case. Let me get the site. It's 731 Southern 2nd at 702. And what that case says, Your Honor, is that when you have a series, in this case, it was a series of videos or a broadcast series, the average viewer, which is sort of the lens that the court has to look through, the court assumes that the average viewer would watch the entire series. So in terms of these video diary entries, which are each one of them is fairly short, the court would need to look at those collectively. And the reason why I point that out and it's important is because there's actually, and we filed this as well, but Exhibit 1 to the declaration that was filed in support of the motion is actually a transcript of the introductory video for the video diary entries. It gives an overall explanation of what they are, how they should be read or viewed by people that are viewing them. It includes statements, cautionary statements, and I'll explain to the court in a minute why that's important, but that, Ms. Baskin said in there's an opportunity that these diaries are a little bit skewed on some of the things because of a memory problem that she discusses resulting from a car accident. She states, hopefully, that people will not view these out of context. And the actual web page for that introductory video diary says, please start at the beginning of this playlist. This video and all subsequent videos in this diary playlist are for entertainment purposes only. And so that's a type of situation where the court would need to consider those sort of collectively. And there's a lot of them. So I understand that's a lot for the court to go through, but it's sort of the framework that was established to look at what's been alleged in the complaint. And as the court goes through that analysis, there's just a couple of rules that I wanted to point out. We have some of these in the motion. But the first one, like I said a moment ago, was that any cautionary terms that the publisher uses, such as things like I have bad memory, these diary entries may not be completely accurate, those have to be considered by the court, that's in the Hay versus Independent News case, which is actually, it's also cited in the plaintiff's papers. It's in the notebook we sent over. It's at tab 22, but it's 450 Southern 2nd, 293. The court also has to consider, in terms of the context and surroundings for each one of the publications, the court has to consider the medium that's being used and the audience for that potential publication. The court also has to assess, in terms of the context of the publication, that includes all of the information that would be known or is readily available to readers of that publication. And that, again, is laid out in the Hay case. And like I said, if there's a series, the court's supposed to consider the entire series. And so here, just a couple of issues to point out to the court on the analysis of whether or not the statements at issue in this case are defamatory or not. So hopefully the court will get the chart of the statements. I'll make sure that, I thought we had that hand delivered, but, and we did file it in the court file. But so statements, there's 59 statements overall at issue in the case. The majority of those are from these video diary blogs. And there's a case that we pointed out to the court. It's the Obsidian Finance Group versus Cox case. And The site on that is 812 F sup second 1220. And we brought that to the court's attention because it specifically states in there that where statements read like a, quote, stream of consciousness, like a journal or a diary revealing the defendant's feelings, that is not defamatory, that it's not an assertion of fact, which is the essential element of any defamatory claim, any defamation claim. And it's a very important ruling, Your Honor. That case would be a good one to look at because in addition to that, which we think is dispositive on all of the statements based on the video diary entries, the court also noted several other indicia that statements made in publications are not supposed to be taken as assertions of fact. One of those was that the statements were made in the context of a heated debate that was going on publicly. And so those articles that I pointed out to you earlier, the Weekly Planet, there's TBT, Tampa Bay Times articles, and we have images of them actually in the motion at pages 45 through 46, where Miss McQueen makes public statements. And the Tiger King back and forth itself, those are things that clearly signal to readers of these publications that there was a heated debate going on. The Obsidian Finance Group case also notes that blogs inherently suggest that statements are not likely provable assertions of facts because of the nature of the publication itself, which is still context. And then, things like name calling. I know the plaintiff says, well, if you accuse somebody of embezzlement and things like that, that automatically qualifies as an assertion of fact, which isn't actually the case. And there's a discussion in the Obsidian case about that using the word embezzle does not amount to accusations of criminal activity when it's actually viewed in the context of the article itself. Which is exactly what you have here, Your Honor. The videos have cautionary statements throughout them. Ms. Baskin says, start at the beginning of the playlist. This video is for entertainment purposes only. Throughout them, it's a warning that's affixed to all of them. And then the articles themselves that were posted on the website, Your Honor, these are the remainder of the statements, and these ones can be found it's really that these are all in paragraph 34 of the second amended complaint, are all of the articles, the statements and articles. They primarily come from one article, which is the title of it is actually Rebuttal to Netflix. So what happened here was after the Tiger King series came out, Ms. Baskin, who is a public figure, defended herself and put out her rebuttal to things that she thought were inaccurate and false in the documentary about her, which is exactly what public figures are expected to do because they have access to the media and means to communicate their position rather than filing lawsuits against people for defamation. They're expected to go out and defend themselves publicly when people say things that are false. That's why public figures are held to the higher actual malice standard, is because that access to the media gives them an ability to defend themselves publicly. And if the court goes through these particular articles, you can see that within the context themselves, I mean, including the titles, Rebuttal to Netflix, refuting Netflix's Tiger King. These are clearly one-sided, one person's point of view about a particular scenario. And we actually cited a case for this proposition to the court. It's the Price versus Viking Penguin case. The site for that one is 881 F 2nd 1426. And it says, even where a statement is subject to empirical verification, it's still protected if it can be best understood from language and context to represent the personal view of the speaker. So, those are the types of things that we pointed out in our motion, Your Honor, that are, when you look at these publications as a whole, it's clearly one person's view of things that happened. The other issue I'll briefly run through on this is that we've also argued to the court that these are protected speech because they involve matters of pure opinion. And I don't think here the parties disagree on the general law either. Statements of pure opinion are typically protected. Mixed statements of opinion, where an opinion is given, but the publication doesn't disclose the facts that it's based upon, those would not be protected. And so if Your Honor goes through and actually, when these publications as a whole are examined, you can see in there that Ms. Baskin lays out the facts that she's made these supposedly defamatory statements based on. There are hyperlinks in the articles. There are documents that are shown. There's documents shown on videos. And the general law on this is that where the speaker presents the facts, it's as the same time as the commentary, a finding of pure opinion will usually result. That's from the Zambrano versus Devinson case, which is at 484 Southern 2nd 603. The Zambrano case also says that even where an opinion is given and not all the facts on which it is based are stated, if there are facts that are already known to the audience, that as well qualifies for protection. The same standards apply that I discussed a moment ago, Your Honor. We have to consider the entire context. You have to consider whether or not it was made as part of a heated debate, which clearly this was, because the articles, for example, were put out to refute and to rebut Netflix. And when you go through the publications, the facts are obviously in there, and the facts are known or available. This sort of loops back to where I began with this, but the Tiger King documentary, the Weekly Planet article, the other articles we've cited in our motion, Ms. Queen's interview in the Ripperjack media has her position laid out there on all of these. And so this is clearly a situation where the statements that are being sued over are matters of opinion based on disclosed facts and not mixed expressions, and therefore they'd be entitled to protection. We also raise, Your Honor, the argument that here it would be impossible for the plaintiff to establish proximate cause. And the statements that we're talking about here, the primary problem, the issue the plaintiff takes with them is that they accuse her of embezzling $600,000, taking out a life insurance policy, things of that nature. And as we've pointed out to the court already, all of these exact same statements were made publicly numerous times by other people, and in like the Weekly Planet article, there's a Tampa Bay Times article, the big cat fight, and these, again, we've actually included images of these in our motion at pages 45 through 47, but we've also filed the entire articles. The identical statements that the plaintiff is suing over were made in these publications. And she obviously didn't sue over those and can't sue over those, including the ones that they've now, statements 50 through 52 in the chart, but the ones from this Barbara Stairs article is the exact same statement that they're suing over on other publications. And what the law says on this issue, Your Honor, is obviously proximate cause, and in most situations is going to be an issue of fact for the jury to decide. I'm well aware of that. But there's in a lawsuit that George Zimmerman had filed against the press over supposed defamation, the court there actually adjudicated as a matter of law that he couldn't establish proximate cause because the statements he was suing over had been made by other people and publicly several times before. So it was impossible to say that his damages were caused by this statement made by one person as opposed to the statements that were out there from all of the other people. And that, Your Honor, that's a trial court decision. So we obviously it doesn't carry a ton of weight, although it was affirmed. It was PCA'd by the 5th DCA at 212 Southern 3rd, 376. But we think this is practically an identical situation here to what happened in the Zimmerman case. And then I mentioned briefly before Ms. McQueen's public figure status, which is a significant issue, not just for purposes of actual malice, Your Honor, but public figures have to also meet the clear and convincing standard in terms of proving the falsity or defamatory nature of the publication, as well as the level of fault in publishing it. The court's probably familiar with the categories of public figures, but you have general purpose and limited purpose. Based on the materials we submitted to the court, I think Ms. McQueen qualifies as a general purpose public figure, such pervasive fame or notoriety that she's been deemed a public figure for all purposes. But she definitely qualifies as a limited purpose public figure. There's 3 components of that inquiry. Whether there's a public controversy, whether the plaintiff played an important role in that controversy, and whether the publications at issue were germane to the plaintiff's role in the controversy. Here, there was clearly a public controversy. There were several, in fact. Tiger King was obviously one of them, but you also have to go all the way back to the disappearance of Don Lewis, as well as the conservatorship litigation, in which Ms. McQueen was a party and played a central role. And I'll note for the court, we filed the transcript, as I mentioned before, to the Tiger King episode. It's at Exhibit 29. And, Ms. McQueen, somewhat in her opposition, tries to downplay her role in Tiger King and saying, well, I only appeared for, 3 minutes in it. But you have to look at what she actually said. And she actually discusses, when her clips are included in that, every one of the topics that are approached in these defamatory statements that she's suing over. She talks about all of those in the documentary. But one of the most important things that she notes in here, and why this is relevant to the second element of the public figure analysis, whether she played an important role, but it's page 22 of the transcript of episode 3 of Tiger King. Ms. McQueen actually states that the only 2 suspects for Mr. Lewis's disappearance were her and Ms. Baskin. So she's an extremely important participant in this public controversy. The statements at issue related to that, I mean, again, as we pointed out, they were rebutting, the Tiger King issue. And one of the most important factors in determining public figure status is access to the media and whether the plaintiff voluntarily injected themselves into the debate. And we have the case law for that in our motion, Your Honor. But here, Ms. McQueen, as we pointed out, voluntarily appeared and was interviewed for Tiger King. She voluntarily appeared for this Ripper Jack media interview, which is posted online, specifically about the whole situation with Don Lewis, the conservatorship litigation, and Carole Baskin, including the allegations and supposedly, the same types of statements that she's suing over. The articles we've already put out, exhibits 30 and 31 and 32 that are addressed in the motion at pages 45 through 47. Ms. McQueen even took part in putting out a commercial that aired during Dancing with the Stars, showing her access to the media. And they had a website, Justice for A. McQueen, that was put out. And so what the law says in that regard, Your Honor, is that people who invite attention by self-promotion can't complain when the attention that they get is not favorable. That's from the Fromm versus Tallahassee Democrat case, which is 400 Southern 2nd at 52. So clearly in this instance, Ms. McQueen's going to qualify as a public figure. And the last thing I'll say on that, Your Honor, is that the Frygood versus Peterson Publishing case, which is actually another case that Ms. McQueen cites. That's at 521 Southern 2nd, 236. That involved a situation where the plaintiff became a public figure because they were involved in a court case, like the conservatorship litigation here, and gave interviews to the press, like Ms. McQueen did here. And the really important aspect of that case is that the court determined that once a person has become a public figure in connection with a controversy, they remain a public figure thereafter, for purposes of any later commentary on that same controversy. And in terms of whether or not it relates to the controversy, that issue, Your Honor, that's the third element, whether the publication is germane to the plaintiff's role. The Waldbaum versus Fairchild Publications case, 627 F. 2nd, 1287, says that so long as the commentary is not, quote, wholly unrelated to the controversy, end quote, that it's protected. So it's a pretty broad standard for the court to keep in mind there. And then quickly, the last 2 points I'll make, and I know I'm getting short on time. So, but in terms of actual malice, Your Honor, once it's determined that Ms. McQueen is a public figure, she has to allege and prove actual malice by a clear and convincing standard. And in the Tobinick Vinovelli case, Your Honor, 108 F. Sup. 3rd at 1309, they define that standard, and it is extremely daunting. It means so clear as to leave no substantial doubt and to be sufficiently strong to command the unhesitating assent of every reasonable mind. It's incredibly strong. Here, the only thing that Ms. McQueen has alleged in her second amended complaint to satisfy the actual malice standard, and again, just an overview of that standard, though, it's been defined as overwhelming. They have to show that the defendant either knew that what they were saying was false or published with a high degree of awareness of probable falsity, such that they entertain serious doubts as to the truth. And in terms of pleading that, Your Honor, you can't just use the buzzwords. And we've cited a number of cases for this. Turner versus Wells, 879 F. 3rd at 1273. Just saying that the defendant published, quote, knowingly and recklessly, end quote, isn't enough. You can't just do that. You have to have actual facts to back it up. And here, the plaintiff doesn't have any, at least that are alleged here. She bases her entire sort of theory on knowing falsity on this stipulation that was executed and an apology in connection with that back in the conservatorship litigation back in 1998. But as we pointed out in our motion, the stipulation actually states it shall not be deemed an admission and it's in settlement of a disputed claim. And the language of the apology itself, Your Honor, says, I apologize for allegations. It doesn't ever identify what those are. And certainly it's not anything that's sufficient to establish that when these statements were published in 2020 has nothing to do with Ms. Baskin's state of mind now, an apology as part of a negotiated settlement back in 1997. And then the last thing for the court, Your Honor, and we once we got the opposition late last week, we filed a brief reply, but we had made the argument that count 4 of this complaint, which was a claim for breach of contract and for breach of fiduciary duty, based on these same defamatory statements, failed to state a cause of action because there's not a provision in the contract that actually prevents Ms. Baskin from saying or doing anything, quite frankly. And they hadn't alleged a basis for a fiduciary relationship or anything of that nature. And the opposition that was filed didn't even address that argument. And so it's, our position that we're entitled to judgment on that without the need for very much argument at all. And I'll answer any questions that the court has.
So you say that I need to view in context a series of things on this blog, I guess it is, correct?
Yes, Your Honor.
Did you provide those to me?
Yes.
Okay. On like a disk or a thumb drive, or
they're in the court file.
Court file. Is it a transcript? What is it?
They're transcripts and the actual videos themselves.
So what do you mean they're in the court file? You give them to the clerk?
Yes. So we can provide the court with a thumb drive with all of the publications, the transcripts and the videos of the video diary entries, as well as the articles.
That would probably be helpful. That way I don't have to go ask the clerk to find them.
Yeah, and I don't know if Your Honor, you probably don't recall, but at the last hearing we had, I actually showed you a notebook that was about 10 inches thick that had that stuff in it, and brought this issue up of how to get things to you. And it was just difficult, knowing how to get that done.
Well, it's probably easier if you have someone drop it off to my office as opposed to me trying to get the clerk to find it.
We'll do that, Your Honor.
So probably be a time saver. Okay. All right. Thank you. Mr. Phillips.
Thank you, Your Honor. I'm going to try to share a PowerPoint to run through this stuff. Can you see my screen? Can you see a PowerPoint, Your Honor?
Your Honor, you're on mute.
Yes, I can.
Oh, good. Okay, thank you, Your Honor. May it please the court. John Phillips on behalf of Anne McQueen. Where we are today, let me do this real quick. Where we are today with what's left is Anne McQueen versus Carole Baskin. When we originally started, Howard Baskin, Big Cat Rescue, and another Big Cat Rescue defendant were a part of this. They no longer are. When we originally started this back in August of 2020, it was a pure bill of discovery. In October, we amended to make Anne McQueen the operative plaintiff and defamation claims the operative claims. All plaintiffs are gone. All defendants are gone except Anne McQueen and Carole Baskin, two people at the center of this dispute. We accepted proposals for settlement on behalf of Howard Baskin, Big Cat Rescue, and Big Cat Rescue and Sanctuary. We amended our complaint on June 23, 2021, which became operative by stipulation. And the current remaining claims are defamation per se, defamation by negligence, defamation by malice, and breach of contract. Those statements are based largely based on daily, sometimes multiple times a day videos that Carole Baskin makes on YouTube. If Your Honor has to watch the whole series, we're talking about hundreds, I believe, of videos. And you'd have to potentially, dedicate massive resources. We don't think that's necessary for the reasons we're going to get into. But the defamatory statements were made largely on YouTube, on the blog that was owned, we believe, by Big Cat Rescue, who has settled, but statements made by Carole Baskin on that blog. The core accusations against Anne McQueen, as have been alluded to this point, are that she was somehow involved in the disappearance or murder of Don Lewis, who was her boss and good friend, and Carole Baskin's ex-husband, and or that she was involved in a scheme to embezzle or defraud Don Lewis, Carole Baskin, or the heirs of Don Lewis. There's actually another issue, and that's where they're combined, that Anne McQueen was involved in the death of Don Lewis in order to cover up the embezzlement. So there's kind of three prongs of what's happened here. The Florida jury instruction on defamation is very clear. What we need to show is a false statement which caused harm to a third party. Those are the three things. We cite a case, Rasner versus Wellington, in the Florida jury instruction. I think this is just kind of common law. I'll add cites when we're getting into some of the specific stuff, unless Your Honor says otherwise. I'm also happy to provide this PowerPoint to you and defense counsel after we're done. So there's defamation, and then there's defamation per se. Well, we're well aware of the heightened standard of defamation per se. And generally, whenever you have defamation, or in order to have defamation per se, you've got to have, as it says in one there in the Blake versus Gistabelli case, 182 Southern 3rd, 881, a 2016 case, that it charges that a person has committed an infamous crime or infamous crime. Not like, one that's on TV, but that it's so loathsome, as I say in bullet point 2, under Florida law, crimes characterized as having infamous nature for purposes of libel per se are murder, perjury, piracy, forgery, larceny, robbery, and similar crimes. This involves certainly levels of larceny and murder here, which we would believe would be an infamous crime or an infamous crime. 2, that it charges a person having an infectious disease. That's not what we're dealing with here. 3, as a separate one, it tends to subject one to hatred, distrust, ridicule, contempt, or disgrace. Certainly being accused of stealing from or killing your boss and good friend would be a disgraceful act. Ors and ands are very important as we go through today, obviously, every day. 4, it intends to injure one in a trade or profession. So the proof of liability for defamation per se requires a showing that the declarant knew or should have known the defamatory statement was not true. Before I do that, I should have read them in order. While we have to prove damages with defamation per se damages actually don't require actual damages. All of that, I think, once we get into discovery, are going to be moot points because Anne McQueen has both. But again, to show actual malice, as defense counsel has so eloquently stated, we've got to show that the declarant knew or should have known the defamatory statement was not true. Well, how do we prove that? Well, these are diary entries, supposedly. They're all over the place. They contain revisionist history, where Miss Baskin is reading at parts, reading things that don't match what's written on the screen at parts, contain modern-day textualizing, and we don't even know what diary she's actually reading. I've put an example up here of a 31-second clip.
September 9th, 1998. There's 2 separate entries for this date. So my guess is that I had one date written, which I think is this first one. And then later I had information from the conservatorship documents that I then inserted into the same day because it happened the same day. So you'll see a little bit of an overlap in what I'm talking about as a result of that. September 9th, 1998, Labor Day. And this was not Labor Day. I was reporting this like 3 days later.
So we're already, Your Honor, to actually watch the whole diary and series, you'd have to watch all of these. And this is just a small 31-second segment of just one video. But it's an important video. because it's from September 9th, 1998, if what Ms. Baskin is saying is true. Well, what happened on September 9, 1998? We're going to get to that. These videos not only contain false statements about Anne McQueen, but Carole Baskin knew the defamatory statements were untrue. As of when? As of September 9, 1998. Despite the claims that there might be one video in the series of hundreds that says, ha ha ha, just kidding, or don't take this seriously, there's hundreds of videos that don't give that context. And
how is something from 1998 relevant to all of this? I mean, that would be outside of the statute of limitations, wouldn't it?
Yes, Your Honor. And let me go back to screen. The 1998 video was published September 20th, 2020, within the last 2 years. So all of these videos that purportedly read old diary information have been the last 18 months of a disparagement campaign against Anne McQueen. If these diaries had certainly stayed under her bed or tucked between her mattresses, you're right. These never would be defamation. But going on YouTube and reading them and blogging about them certainly has published new information. So, going back to the malice standard, Baskin has specifically admitted these allegations against McQueen were unfounded and without full knowledge of the facts. She did that back in 1998 in a signed apology concurrent with settling slander and defamation cases with McQueen for $50,000. Same type statements that she embezzled or stole and was involved in the death. That statement, which hasn't been disputed as authentic, says, I, Carole Lewis, apologize to Anne McQueen for all of the allegations that I have made about Anne McQueen. I never would have done so if I had not felt that Anne McQueen was trying to take over mine and Don's business. Upon further investigation, I have found that the allegations were made without full knowledge of the fact, which I now know are unfounded. So, I think this document alone goes back to proving defamation per se, as I scroll back too far, that proof of liability for defamation per se requires a showing that the declarant knew or should have known. She not only knew or should have known, she wrote it in a signed apology and settled for $50,000. That same day, she published this this is a minute and 43 second clip out of, I think,
Okay. And before you play this, do you want me to take these clips down into the record?
I would like that, probably, to keep it with context. And again, if you need this, we can provide it to you.
Thank you.
As part of our settlement, Anne insisted on an apology letter. It was the only way she would agree to the settlement, which she never did honor. She had to be compelled by the court during the conservatorship to release all of the money and properties she was holding that did not belong to her. I felt like signing this only hurt me and no one else, so even though I resisted, I gave in. Now she uses it to discredit me, even though she never held up her part of the deal that caused me to give her this signed note. I saw it for the first time today in Chris Spada's Tampa Bay Times article, and I give a link to the article. And then this was a copy of the notice that I had signed with her. So it's not listed here, but what you'll find is it takes me until, 2001, I think 2002, fighting her in court, constantly winning against her in court, and then having the court threaten to impose sanctions on her, at which time her attorney quit. And then she hired the attorney that everybody was calling Don's attorney in Tiger King. He may have represented Don a couple of times, but he was not our attorney. Joseph Fritz was not our family attorney. And yet they were positioning that, so it made it look like he was a friend, when in fact he was representing Anne against me when I was trying to get back the money that she had taken from our business and put into her maiden name. So that's why the apology letter was written, so that she would give the stuff back, and then she didn't. And it had to be taken from her by the court.
So that gives context to the September 9, 1998 video, again published September 20th, 2020. We're rehashing old wounds, and in that full version of that full video, it seems to be revealing matters which occurred at a mediation. It falsely describes court proceedings. The longer video directly accuses a gentleman by the name of Wendell Williams of being involved in Don's death and disappearance, and then links Ann with Wendell Williams. We're going to get more into that in a second, and discusses some scheme to defraud that she ultimately links to Don's death and disappearance. Obviously, Ann does categorically deny all of this, and this is one of hundreds of videos that have been released within the last, approximate year and a half. As a term to that settlement back in 1998, Carole Baskin provided a $50,000 sum on behalf of herself and the conservatorship estate for libel and slander, again, related to these same allegations. Untrue allegations. And as a result, Ann released liability. She agreed not to sue and pursue further claims. Therefore, here we are with a breach of contract that we'll discuss as we go forward. Baskin's claims of forgery and fraud tie to her husband, Don Lewis. So we're going to get into some core issues regarding, who did what. And frankly, it's not Ann McQueen's job to decide who did what. It's just that she just didn't. And Carole Baskin knew or should have known that she didn't. And she's saying these things to either direct attention, create more attention, sell cameo videos, get YouTube revenue, get Facebook revenue, whatever reason, but not because of some public controversy. This is another 31-second video.
I allowed Don to make the mortgage back, $480,000 mortgage, to his Costa Rican corporation with the provision that he show like faith and consideration and put me in his will and give me power of attorney for him, so that if anything ever happens to him, all of the money that I am sending down to Costa Rica will not be tied up in courts forever. He agreed. Turns out he had already had Ann McQueen forge my name on the closing documents, and then she notarized it.
These are alleged 1996 statements, again published in the last year and a half, referenced in our complaint, which just gets into all of the different theories that Carole Baskin had regarding Don Lewis. Don Lewis being complicit with or ordering Ann McQueen to commit forgery. All of these theories, which once we get into discovery, are going to be proven brutally untrue. Even in this very case, when it was a pure bill of discovery, we had a claim against a defendant named Susan Bradshaw, who worked for Carole Baskin, and related to documents that Carole Baskin produced, a will and a power of attorney. Miss Bradshaw said that it was somebody else who signed her name. These were documents that Ann McQueen wouldn't have had any control over, power over, and in fact were adverse to her position. So, the only reason we're not in discovery right now is because of the SLAPP motion, and we're gonna come back to that, and to some extent the 770 motion. But generally, we should be conducting discovery and trying to get to the bottom of this before we rule on motions for summary judgment and to end the case. I only have a couple of more videos, Your Honor, and then I get into the legal aspect, and we'll roll on pretty quick with my presentation. But Baskin's allegations of forgery and embezzlement have constantly been leveled against Ann McQueen, especially during the last 18 months. These are videos, 21 seconds and 14 seconds, respectively.
Everyone's been pointing at Ann McQueen and saying she's responsible for separating Don and I. No one seems quite sure if she knows where he is and has vowed not to tell, or if she knows he's not coming back. I've blown off the accusations because she's been my friend for 16 years. Or has she? I spent the day in our real estate office quizzing Anne McQueen about the title search I did on her, showing $500,000 plus of our properties titled in her maiden name. This had all been done in just the past few months.
So here approximately 10 days, if you believe this is a diary being read, 10 days post Don Lewis's death, there was accusations of death, involvement with Don Lewis's death, and embezzlement. And again, these are republished new August 9th, 2020. And not just that, we get into dozens and dozens of statements made on blogs and videos, Your Honor. As to theft and fraud, our secretary had transferred over 600, all of these are in our complaint. Our secretary had transferred over $600,000 from our accounts to her own. I discovered that one of our secretaries had embezzled hundreds of thousands of dollars and made herself the beneficiary of an executor of his will. Not true. When I lost my husband, Don Lewis, in 1997, I discovered that our secretary, who I thought was my best girlfriend, embezzled over $600,000. My friend and secretary embezzled $600,000. $1 million life insurance renewal came in, and she changed the beneficiary to herself. Anne McQueen, presented by Netflix as Don's trusted secretary, was actually embezzling from him. Anne was moving our properties into her name and didn't trust them. And we go on. Her tune may change entirely if she thinks she could be punished with jail time. I would drop the charges provided she properly deeds everything back to me. Anything she can prove is hers, she may keep. A life insurance policy owned by Anne McQueen on the life of Don Lewis was taken out a couple months before Don Lewis's disappearance. She was feeding people with nothing but lies. She's sure Don isn't coming back. She's spiriting documents away, meaning to hide all the stuff that was going on with Anne putting stuff into her name. She didn't do anything wrong. She would say that Anne didn't do anything wrong if you just give me back the money and properties. And we go on. I can see no reason to protect her any further. Can she be arrested for embezzling? And can your firm represent me in the ensuing lawsuit? These are in videos she reads on YouTube. The proof is overwhelming. Why I want to see Anne in jail for embezzlement. Look, when you have a public figure going on YouTube while simultaneously on Dancing with the Stars and other shows and constantly accusing somebody of embezzlement, it does have an effect on them and their surroundings. We go on, $600,000 embezzled over and over and over. As it relates to the death, 4 months after I discovered the embezzling and Don ordered her to sign the properties back over, she refused and Don mysteriously disappeared. The life insurance policy owned by McQueen on the life of Don Lewis was taken out a couple of months before Don Lewis's disappearance. A few months before his disappearance, we caught her embezzling. So we're linking these two things up, which is fairly significant. Anne McQueen had been successful in taking over our estate by appointing conservator, this goes back to Linda Sanchez, that Anne had the most to gain. She and Wendell may have gotten away with doing harm to Don, but they haven't escaped all of their treacherous deeds. This isn't just social commentary. This is a scheme to paint somebody else as murderous and thievery. This is, I think, the last slide on this. I did not kill my husband. I did not have him killed. And if he'd been killed, I don't know who may have done it other than my suspicions about Anne and Wendell. I believe that if there was foul play in Don's disappearance, that Anne and Wendell are behind it. She's sure Don isn't coming back. I want Wendell and Anne to pay for Don's disappearance. There's other statements about her hauling boxes off of the property, the life insurance, and other things that are all in our complaint, but show that this isn't just some, no nexus, no proximate cause strategic lawsuit designed to just waste Miss Baskin's resources. This is a bona fide claim for defamation and defamation per se. The first defense they argue is under 770.01. I actually had to look this up. And it originally, it states, this is the statute as written, that before any civil action is brought for publication in a publication or broadcast in a newspaper, very important, periodical, or other medium for libel and slander, there's a 5-day notice requirement. True. This all started back in 1933 when those were really the only ways you got media. And so it was newspaper or periodical then, that's it. Then TV came around. They said, wait, 1950. Let's add TV. As the Florida Supreme Court said in Ross versus Gore, 48 Southern 2nd, 412. The intent was to afford to newspapers and periodicals an opportunity in every case to make a full and fair retraction and mitigation of the damages which a person may have suffered by reason of the publication. All right, so that's really important, and it's going to go all the way to today. A newspaper, a blog, is a third party. A third party should get some notice of what they've done wrong and get some protection of that and be allowed to retract it and pull it down. It's extremely important as it relates to the First Amendment. But the Ross Court specifically distinguished the special privilege of newspapers and periodicals to not be held by private persons. If this was still a case against Big Cat Rescue, I think 770.01 might have been violated, but that case was settled. We get into, kind of modern day stuff, and we are in a new world where blogs and YouTube are around. And I'd agree that if Miss McQueen decided to sue YouTube, they would be due a 770 notice. They're third party. What did they know? Or if they wanted to sue whoever this Ripper Jack, they want to sue Ripper Jack, he's a third party. 770 notice is required. But these are first party statements by a private person. So you look to Bridges versus Williamson, 449 Southern 2nd, 400, a second DCA case. Had the legislature intended to extend the application of the statute to non-media defendants, it could have inserted such a provision into the statute at that time. A few years later, 1990, other medium includes television and radio broadcasts. I've already discussed that. The cases have gone on and on. A private citizen making allegedly defamatory statements over a citizen's banned radio is not a media defendant. Private individuals posting allegedly defamatory statements on an internet message board, not a media defendant. The cases, this law is actually real simple, and it's not what I think the defendant seems to think it is. The Zelenka case is a big case because this was the test on internet message boards. Somebody went on an internet message board and posted something, and the court denied cert, holding mere internet using private individual is not a media defendant. If somebody's making first party defamation, they know what they did. They don't need to be told they did by a 5-day notice. And so we get into the core cases, the two main cases the defendant cited, and they're very, very, very distinguishable. In Comins versus Van Verhees, 135 Southern 2nd, 545, it was another medium. YouTube is another medium. Carole Baskin's blog, whoever hosts it, controls that other medium. But what happened to Mr. Comins is he shot several dogs that were attacking cows. and it made the news, and everybody was talking bad about Mr. Coleman's. If it had been in 2021, he'd have probably been canceled. This guy, Van Voorhees, decided to cancel it, even back in 2014. And so he published a whole blog called Public Intellectual, which he said was founded to publicly comment on issues of public concern in an intellectual manner. It wasn't his dog. It wasn't his cow. He didn't know Mr. Comans. And so he published the blog. And the trial court found that the blog fell under the rubric of other medium. He's a third party. He needed some notice and to make a decision whether he should take it down or not. Baskin wasn't commenting on something as an outsider or as a blogger. The other case they cite is Plant Food Systems versus Irie. Bear with me, I can't see my own site. 165 Southern 2nd, 859. This is one where there was a online website by a group called, I'm going to mispronounce it, but Elsevier, Elsevier. They are an internet publisher of scientific and technical journals. And guess what? They said something that somebody didn't like. They're a third party. And McQueen would have to provide that notice to YouTube, not Carole Baskin. This was a third party case. 770 doesn't apply. We've actually sent a 57105 notice on this issue. Despite it, we want to try to comply. And so we've sent 2 notices out of an abundance of caution. The problem is Ms. Baskin continues to release more statements, including 4 days ago. And so in theory, we would have to serve a notice and file a lawsuit every time she decides to hop on YouTube and make a statement. And it would have to be a new lawsuit because you can't amend.
Well, you would have to file a notice as it pertains to what's in your lawsuit. If she says something new, wouldn't that be a different lawsuit that isn't really at issue for me right now?
It potentially would be, but our issue is that these are all the same core statements, and we haven't amended to add the new statement in.
Regardless of that, you've done this notice after the filing of your complaint, correct?
Yes, Your Honor.
Okay.
And so
does that essentially fix it and cut this off?
We believe it does. So dismissal is without prejudice on these cases, as long as, and that's the distinguishing factor, the statute of limitations remains. And so we still have 6 months on the statute of limitations on these cases. And courts have done it 2 ways. 3 ways. They have allowed filing within the lawsuit. So look, you fixed it. Move forward, let's go. They have said, okay, you're going to have to file a completely different lawsuit, so go pay the $400 again and file a different lawsuit. Or if the statute of limitations is run, they said, sorry, you should have done this. So that's generally what the case law is. But even if notice was required in this instance, and we strongly contend it wasn't, we've since served the notice and made our complaint painfully specific with all these claims. The next issue is SLAP, Your Honor. I actually did these in a separate order based upon their motion, but they actually argued, I think, SLAP first. So SLAP is an acronym for Strategic Lawsuits Against Public Participation. All those words are super important. Strategic, lawsuit obviously we have here, against public participation. The legislature, when enacting it in Florida, said a person shall not cause to be filed a lawsuit without merit and, big and there, primarily, big word there, primarily because such person or entity has exercised the constitutional right of free speech in connection with a public issue. the Florida legislature described that these suits, the plaintiff sues a speaker alleging defamation or other civil wrong, not for the purpose of pursuing a case for damages, but rather with the primary motivation to intimidate the target into silence. Ms. McQueen is not intending to intimidate Ms. Baskin, nor do I think can she. If she was intending to make this a big deal, she wouldn't have settled with 3 of the 4 defendants. But the question is clear as to SLAPP. The lawsuit has to be without merit and a big and then primarily because of constitutional right of speech, which this is not protected speech. This is accusing somebody of infamous crimes. We put these slides back in here, but I did it for a reason. I'm not going to reread them to Your Honor or go through the statements. But we're talking, our merit is the embezzlement and forgery and fraud and death of Don Lewis claims. We meet the burden to go forward with discovery. Certainly, we can address a lot of these issues on summary judgment, but we haven't even been able to take discovery. So Ms. McQueen's defamation claim is not a SLAPP claim. The defendant's statements are not constitutionally protected. The lawsuit has merit. Baskin contends these statements were protective speech. As we've established, they're not. They were first-party statements by Baskin, which she previously declared to be untrue, that allege a scheme to defraud or embezzle, a plot or plan or involvement with a plan to kill Don Lewis. And frankly, were designed for Baskin's own notoriety or profit. Again, Ms. Baskin can't have it both ways about apologizing to these statements and then continuously regurgitating them as if they're true without any context or disclaimer. If every video had a disclaimer, I think I would have a hurdle to get over in discovery. But this isn't the case here. These videos don't have disclaimers. A publication is liable per se.
I'm sorry.
Yes, Your Honor.
Do you mean if every video that Miss Baskin's put out had a disclaimer, or do you mean every video anybody ever posted?
Just Miss Baskin. Just Miss Baskin. If Miss Baskin.
You're saying that Miss Baskin would have had to have put a disclaimer at the beginning of every one of her videos.
Yes, Your Honor. If she's going to engage in textbook unprotected speech of accusing somebody of a crime, in textbook disparagement, she would I think need to do more to say, well, this is what I said in 1998, but oh, by the way, I apologized. She's now saying in these videos the apology didn't matter, and she only did it so that she could, try to get a gain on getting properties back. And so that's why I said she can't have it both ways. We need discovery to figure out what is the story here. The general rule to be adhered to in criticizing or commenting on matters of public interest is to confine the comments on the matter itself and not descend to personal attacks on private character. Ross versus Gore, one of these seminal First Amendment cases, 48 Southern 2nd, 412, U.S. Supreme Court, 1950. Freedom of speech and press do not carry with it the freedom from responsibility in the misuse of those rights. You have the Larry Klayman body of cases that talk about the publication is libelous per se when it imputes to another criminal offense amounting to a felony. Miami Herald, which I think was cited by the defendant, versus Brodingham, 127 Southern 2nd, 718, says essentially the same thing. Ms. McQueen simply wants to address the damages made to her private reputation through the lawsuit, not strategically involve herself in any public controversy. And frankly, Your Honor, this is a core private controversy. Because Tiger King picked it up and people watched it, I don't know that the death and disappearance of Don Lewis is what's going on with Trump on any given day. This certainly received media attention, but this isn't this isn't a core debate that everybody's, publicly participating in. She's not sought an injunction. She's not, running around further defaming herself, trying to defend herself, trying to become a public figure. And like I said, she's actually quietly settled cases. Slapping conclusion, Baskin's admitted these defamatory statements were untrue and unfounded at a point and paid $50,000, and now chooses to republish them for reasons that I think discovery will reveal. It's not a public issue. Baskin wrongfully and inappropriately seeks to shift blame from Carole Baskin, because that's the thing. She's getting blamed for this, and that's not by McQueen's doing. She never said that. But you can't say wasn't me, it was McQueen, and say, oh well, I was just defending myself. Not if you don't have the evidence to prove it. So that's slap in a nutshell. The rest of the stuff is kind of quick hitting stuff. Those are the two, Your Honor, that we believe 770 and slap are the ones that aren't motion to dismiss for failure to state a cause of action, give it another shot type claims. It just depends on how Your Honor would rule. But 770, even though we don't feel like it's applicable, we've actually already amended and added the notices in there. And then slap would be that slap's the reason we're not conducting discovery. And so the rest of this stuff, we feel that discovery would be, helpful to flesh out the issues. But to quickly hit opinion, hyperbole, or rebutting a TV show were argued, and it's just not true. That's not the standard. The defendant contends that virtually all of the statements McQueen has made are not actionable because they cannot reasonably construed to communicate the defamatory meaning that McQueen apparently attributes to him. It's not McQueen attributing these things. It's what the messages speak for themselves. They're not mere opinion. These are the worst things one could say about another in classic unprotected speech. This wasn't a throwaway opinion that Miss McQueen did something nefarious. She's very specific. And at one point it was argued, I think, in a motion that, well, she said secretary, generally. Well, she's doubling down and saying this was this secretary. It was Anne McQueen. It was my best friend. And so, certainly some post-discovery issues can flesh this out. The case we cite is another Clayman case, Clayman versus Judicial Watch, 22F sub 3rd, 1240. The plaintiff argued that the Facebook post imputed him with having committed an act which constitutes the infamous crime of elder abuse under Florida statutes. That's significant, and that's more what we have here. You can't sue Facebook, or you'd have to, do the notice and good luck with that. But that's not what we have. We have a first-party statement. Florida law, crimes characterized, I've already talked about what infamous crimes are in Florida. The Florida Constitution even says every person may speak, write, and publish sentiments on all subjects, but shall be responsible for the abuse of that right. She's admitted these were untruthful. No First Amendment protection. McQueen is not a public figure. These are issues that we should flesh out with discovery. Nothing in the four corners of the complaint would substantiate Ms. McQueen being a public figure, although she has pledged actual malice in addition. But, the public figure status is a question of law to be determined before the court. Frankly, Your Honor doesn't have enough information at this point. And the only reason this is bootstrapped in now is because of the lack of discovery. Once we get into discovery, I think Your Honor can flesh out what category and we can proceed. but she has no pervasive fame or notoriety. She appeared for 189 seconds of a 358-minute series. I know there's a 1997 article, a 1999 article referenced, and a random guy's YouTube. I don't know that that's going to escalate or very far up that chain on public figure. But she absolutely did not play an important or prominent role in these matters. And citing to an article published years ago doesn't escalate her. Further, she's alleged actual malice. We've talked about that. The defamation standard in New York Times versus Sullivan is super important. It's unprotected when the speaker committed the tort with actual malice. Regardless, she gets to go forward. But again, these are issues that should be fleshed out as we go forward. Fair report of court documents. I don't believe they argued this, but essentially there was an argument in motions that that they've referred back to a court website, and thus these statements had some sort of protection. That's not what the fair report privilege is actually all about. Further, again, these things need to be fleshed out with discovery, but a fair summary of allegations in court documents or proceedings is protected. These embezzlement, Anne has never been arrested, charged, accused, indicted, arrested, I've said them all, convicted of anything of this ilk. There's not been a civil suit. There wasn't a civil suit for civil theft. None of this has happened. So I don't even know why this is applicable. Proximate cause, Your Honor, I think they mention that's usually a jury question. We're required to allege some damage. We have alleged some damage. The rest we can get into once we get into discovery. Breach of contract, again, for purposes of stating a cause of action, we believe we did. Plaintiff believed the cause of action was stated for breach of contract. Defendant settled slander, and actually they both settled slander and defamation claims for $50,000. Term of that settlement required an apology. As a result of that settlement, as we showed you early on and is attached to our complaint, she waived valuable rights to not pursue certain claims. So, to the extent there's breach that she's now being slandered for the same things, we would elect to have that issue decided, in discovery. In conclusion, Your Honor, and this is it for us, our complaint is largely overly convoluted because of us trying to keep up with 770-01, which we don't feel is applicable to this case. Even 4 days ago, Baskin made similar statements. So if this is all a diary that's ongoing, there'll never be a ripe day for these lawsuits, or there's going to be 20 of them. This is a video from 2014, allegedly reading a diary from June 9th, 2014, posted 3 days ago to YouTube.
When I lost my husband, Don Lewis, in 1997, I discovered that our secretary, who I thought was my best girlfriend, had put about $600,000 of our property into her maiden name. At the time, we had several secretaries in the office who managed our real estate investment business. When I believed that they colluded to cover the transfer of wealth away from Don and I that had happened without my knowledge, I fired all of them and begged my mother, who was trying to put in 20 years at Gulf Control for her full pension, to come handle my finances.
We started lawyer meetings on this case over whether this was a complicated litigation case. It's not. It's a case that begs for discovery and a potential jury trial to resolve whether this constitutes defamation as a matter of fact and as a matter of damages. Thank you.
All right. Mr. Vogt, do you have any brief rebuttal?
Very brief, Your Honor. I just want to highlight a couple of issues. The argument that Mr.
Before you dive into that, Mr. Phillips offered, and I am going to ask that he provide his PowerPoint both to you, Mr. Vogt, and to my office as well. Please, you can email it to my division email. I'm sure you have Mr. Vogt's email.
Yes, Your Honor.
Mr. Vogt, I'm sorry. Go ahead.
Oh, that's okay, Your Honor. Just a couple of quick points. With respect to Mr. Phillips' argument on the notice requirement under Chapter 770.01, and the sort of theory that it has something to do with sending notice to a third party, that's inviting error, Your Honor. The entire intent of this statute is to give notice to the person who publishes the defamatory statement so that they can retract it and avoid a lawsuit. It's explicitly laid out in the case law that we've already cited. The Mancini case that we cited for the court, 702 Southern 2nd, 1376, goes over that. Specifically talks about how the ability to print the correction, apology, or retraction is dependent upon first receiving notice of the alleged defamatory statement. Commons was a first party. The individual who got sued, the defendant in the Commons case that we keep talking about to the court, was the individual who operated the blog. It's the same thing here. Ms. Baskin runs the page. The fact that there's a hosting site for that doesn't make a difference like a YouTube. It's her page. The same thing's true with respect to the Big Cat Rescue website. And we cited the Mancini case to you before because that case also makes clear that you have to give notice not only to the entity on whose website or page is posted, but also to the author that you're suing for that supposedly defamatory statement. So, I mean, it would just be, it would be a reversible error to go down the line that Mr. Phillips has suggested on that. Whether someone's a third party or not doesn't even factor into the equation because the statute requires notice to the person who made the statement. And another thing that's important in Mancini, and this ties into, again, the argument that Mr. Phillips made without really citing any authorities, that it's okay to let someone send the notice out after the lawsuit's filed and then amend. Mancini says that if Section 770.01 applies, a defendant's entitled to certiorari relief from the trial court's refusal to dismiss the complaint for failure to meet this pre-suit requirement. And that's exactly why we went through the other line of cases that we had talked about with the court on that issue. Because they all come to the conclusion that in a situation like this, you cannot amend to fix this problem. They require the court to dismiss the case, and then they have to refile because notice under the statute is a jurisdictional prerequisite. A number of times Mr. Phillips made arguments concerning, well, discovery will ferret this out, discovery will ferret this out. Our motion does not raise any issues that require discovery. The arguments we've made, whether 770.01 applies, whether or not notice was given, which it wasn't before the claims in this case were filed, that's undisputed. Whether the statements are defamatory on their face, whether their opinion, whether Ms. McQueen is a public figure and therefore has to allege actual malice, those are all matters of law that the court has to determine at the outset of the case based on what's been alleged. So we have evidence that we filed in support of this motion, but the majority of that is just the entirety of the statements because the plaintiff didn't file them with their complaint. What he's trying to get the court to do here is to, punt this decision down the road until some discovery can be done. That's sort of what the court did in the Gundel case. I know because that was my case. And the trial court there got reversed by the second DCA because it can't kick the can down the road when these anti-SLAPP motions have been filed. They've got to be ruled on based on the materials that were put in front of the court, including, any of the evidentiary submissions that the parties have made. So again, and Gundel was a case, Your Honor, that also was taken up on cert because the court says that because the anti-SLAPP statute involves First Amendment rights and it gives someone an established right not to be sued in the first place, just like 770-01 does, that, a denial of an anti-SLAPP motion can be taken up on cert as well, because it involves speech. And again, Mr. Phillips, tried to make a point of the fact that, well, Miss McQueen didn't try to seek a temporary injunction. Well, you can't. It's a prior restraint. Under black letter Florida and federal constitutional law, you can't seek a temporary injunction in a defamation case. So, a lot of things have been said that kind of sound good on general premises about the need to compensate injury, when people have been defamed. But really, those things don't matter because the law looks at the statements themselves. And we've already, pointed out to court, and we'll submit all the statements like we said we will. But when you look at these statements in context as a whole, including things like hyperlinks and including explanatory statements, like, for example, a lot was made and a lot of individual statements pulled out of publications were made about the embezzlement of $600,000 and the taking out of the life insurance policy. And Mr. Phillips also said, I think near the end of his argument, that Ms. McQueen was, quote, never accused, end quote, of embezzling money in any proceeding. That's just wrong. We've attached, actually, to our motion, our anti-SLAPP motion, as exhibits A and B, the pleadings from the conservatorship case where Carole Baskin made allegations accusing Ann McQueen of those very things. Specifically, in the defamation, the properties in her own name, near the amount of $600,000, the taking out of the life insurance policy. Exhibit B to our motion, it's paragraphs 4 and 5. They're specifically in there. So that's just wrong. And the reason why I point that out as well is because when you look at the statements in isolation, like Mr. Phillips has done, it doesn't take into the context that are in the publications themselves. And there, you'll see, Your Honor, when you read these articles, that when Carole Baskin makes a statement about that, she'll have a hyperlink, for example, to the actual, an annotated docket of the case identifying the pleading that those allegations were made in. Exhibit 34 that we filed is the actual annotated docket, and it's hyperlinked in this rebuttal to Netflix argument. And I mentioned this earlier, Your Honor, but just because a statement has a criminal accusation in it, whether it's embezzlement, thievery, theft, anything like that, it does not automatically ring the bell that statement is actionable. In fact, the case that's cited by Ms. McQueen in her opposition, this Palm Beach Newspapers versus Early case, 334 Southern 2nd 50, the statements in that case accused the plaintiff of cheating and stealing. And the court said that that's not actionable because in proper context, the statements which defendants actually made do not carry the implication suggested by the plaintiff. So you can't have situations where someone being accused of embezzlement in one article in its context potentially is actionable, and in another one it isn't. And so that's why it's so important for the court to consider the entirety of the context, precautionary statements that were made. And I know Mr. Phillips said that, well, if there was a disclaimer on every one of these videos, then he'd have a tough time. Well, Judge, as it comes to, with respect to the video diaries, one of the reasons I went through with you the introductory diary entry, the Carole Baskin 001, which sort of set the table for all of the rest of the videos, was because it said to readers at the outset, gave them disclaimers. My memory is foggy. These are my diaries. They're for entertainment purposes only. I just want to tell people my story. And then even the diary videos that Mr. Phillips played, you could tell that she was reading from a diary, and it was diaries from years ago that she was putting out publicly so that as she explained, it was going to just give her story from the perspective of what her thoughts and feelings were. And that's why I cited to the course the Obsidian case, because that's exactly what the court acknowledged there. That when you have someone who's making statements that are from a diary specifically, it's a stream of thought or consciousness. It's not like you're going out and asserting facts against people, and that's a significant problem that they have. But the anti-SLAPP statute applies here. It's you're talking about speech, and you're talking about potentially protected speech. That goes to the application of the statute itself. The arguments about whether or not there's merit to the case, whether or not it should be thrown out, that goes to the second component. But speech is protected, and to suggest that the speech at issue here is not about a public issue, or that Ms. McQueen is not a public figure. I mean, that's why we went through the exercise, Your Honor, of putting these articles, not only filing them, but putting them in the motion itself, showing that Ms. McQueen, not just back in 1997 and 1998, 1999, I mean, one of the articles that we include in our filings was one that was put out by the Tampa Bay Times after Tiger King. And Ms. McQueen was interviewed for and quoted in that article defending herself against the statements that she's complaining about in this case. And the Ripperjack media was not just some random YouTube guy. I mean, that was, I believe, approximately an hour-long interview in two parts posted on the internet where Ms. McQueen went through and refuted, challenged the things that Ms. Baskin had been saying, which is exactly what she should have done. That's what she's required to do because she's a public figure. So she clearly qualifies for that. And that's the same reason that the anti-SLAPP statute applies, and it's the same reason that the notice condition precedent statute applies, 770.01. And you're not, by the way, and I heard Mr. Phillips right at the end say, the four corners of the complaint doesn't show something. We filed a reply yesterday, Your Honor, but the case law was really already in our filings already. You are not limited to the four corners of the complaint on an anti-SLAPP motion like this. In fact, that's one of the reasons that the trial court got reversed in Gundel, was because it didn't consider the summary judgment component, and it wouldn't consider anything outside of the pleadings. And the second DCA said you cannot do that in an anti-SLAPP situation. And then the last point about Ms. McQueen only appearing for 189 seconds in Tiger King, those were pretty critical, 189 seconds. They addressed every single one of the subject matters of the defamatory statements that are at issue in this case. They were used to accuse Carole Baskin of not only killing her husband, but trying to cover it up, forging a power of attorney, accused her of putting him in a meat grinder. And then at the end, Ms. McQueen said, in the context of the police talking about who the suspects were for Don Lewis's death, that the only two suspects were the people closest to him, who were Miss McQueen and Carole Baskin. That's something Anne McQueen said herself. So to suggest that she is not a public figure when she voluntarily appeared in a Netflix documentary that's been seen by over 64 million people and been discussed on a worldwide basis, when she, in that series, said that her and Carole Baskin are the only two suspects in Don Lewis's death, that doesn't qualify as an issue of public importance, or that she is not a public figure. It just does not pass the smell test, Your Honor. So we believe that the court should dismiss this case, find the anti-SLAPP statute applies, dismiss it under 770.01, but also dismiss it because these statements at issue are not actionable, and rule in our favor on the motion.
Okay, I'm on mute. Oh, I'm not on mute. Okay, thank you all very much. You all have given me an enormous amount of material related to this. I've looked at it, but I haven't studied it thoroughly, which I would like to do. I don't get these things, and this is not a criticism of you all, it's just the nature of the business. I get these things shortly before the hearing, so I don't have a lot of time to review them, although I tried to look at as much as I can. So I'm going to spend some time looking at this before I make my decision. I know that you all would like to have an answer to these questions as soon as possible, which I will certainly give you, but I will just ask you all to be patient with me given the volume of information, cases, attachments, etc., that you all have given me. So be patient with me. I want to make a thorough review so that I can make what I believe to be a good, legally correct decision, because I know this is important to both sides. So I want to make sure that I dot my I's and cross my T's for you all, okay? Mr. Vogt, you're going to provide the clips, I think, of the videos.
Yes, sure. I'll submit on a thumb drive.
Okay. And Mr. Phillips, you're going to forward the PowerPoint.
I'll get that over. All. Is it okay tomorrow, Your Honor? It's 5:04. Yes. Okay.
Yep, that's fine. Tomorrow's fine. I mean, I think it's just sending an email, but you can have longer than tomorrow if you need be. Mr. Vogt, I don't know how long it's going to take you to transfer that to a thumb drive. So
we can probably get it done tomorrow, but definitely by Friday.
Well, if you don't get it done until Friday, that's fine too. Okay. I have plenty to start on. Okay.
Okay, before everybody leaves, Judge, are you done? I mean,
no. Anything else?
Thank you, Your Honor.
Okay. Madam Court Reporter wants to talk to you for just a second, so I'll let her do that.
Thank you. I just want to make sure that Mr. Phillips also sends me the PowerPoint. So I'll give you my email address. Are you ready? And then also I just need to know who Jack, I don't know if it's supposed to be Smith.
It's just an observer.
Okay.
Anybody else that's on is just an observer that if this were in court would be sitting in the back of my courtroom watching. So
okay, no problem.
You don't need to worry about anybody that I have not identified, okay?
Okay, thank you. John, it's T as in Tom, M as in Mary, D as in dog, S as in Sam, 70@gmail.com.
Let me repeat it, please. TMDS70@gmail.com.
Yes, thank you. And Shane, do you want me to transcribe the deposition? The hearing?
Yes, please.
And do you want a copy, John?
I'll let you know.
Okay.
Okay. Thank you very much, Judge. Appreciate it.
Thank you all very much. I hope you all have a good evening.
Bye-bye.